frivolous. We have been raising issues we believe are serious and weighty. We have no interest in raising frivolous issues. And I believe that is why this honorable court gave leave to appeal. This court will not give leave to appeal against any frivolous points.
Thank you, Senior Counsel.
My Lord Presiding Judge, permit me, speaking on behalf of the 9th petitioner, there is a concern that we have in view of the directions that have been shared by my Lord Justice Mrima, and my Lord, the comments that have been made by my senior, Dr. Muthomi Thiankolu. My Lord, indeed, there is a preliminary objection that we were served by counsel representing Professor Kithure Kindiki, a PU. And my Lord, just to assist us, I remember in the year 2021, when there was a challenge on the appointment of the Chief Justice, my Lord Justice Mrima had, in that instance, given a conservatory order while there was a pending preliminary objection on record. And when the state went to the Court of Appeal, there was direction that was given at the Court of Appeal that when there is a serious attack on the jurisdiction or the authority of the court, especially in view of a preliminary objection, then it is incumbent upon the court to first consider the merit or otherwise of the preliminary objection that attacks the jurisdiction of the court before perhaps we can go to any other matter or business of the court. I have with me, and I will share with the court, the decision that was made after a decision was arrived at by my Lord Justice Mrima and 2 others.
Thank you.
Thank you.
Thank you very much.
My Lord, is it possible that we just proceed?
Counsel, we don't use that kind of language. I think Senior Counsel Paul Mutte is right that frivolous proceedings are not in this court. They may be elsewhere, but not here. My Lord Justice Mrima will give directions.
We proceed as a directed, applicants.
My Lord, I was on my feet. This is on behalf of the petitioners on the issues of time allocation. My Lord, the respondents have, throughout this matter that has been going on, sought to have a time allocation scheme whose effect would be to guard the petitioners from presenting their case. My Lord, in the normal course of things, and this is a bench, one of the 50th or 70th bench that we are hearing before, the first business of the court before the directions of hearings are given, which we thought we could do on Friday, has always been what is the estimations of the advocates of the time that is necessary for them to do fair representation within the meaning of Article 50 of the Constitutions. My Lord, we are here, we know the urgency of the matter. But as petitioners, on that issues of time allocations, the petitioners wants to plead and beseech the court that each of the application by the petitioners, we shall need 1 hour each to carry out the instructions of our client. My Lord, you have seen the bundle of documents that everybody is having here. This is a court of record.
I'm sorry to interject. Start with your 20 minutes. If they are not enough, we will consider. We're here. We shouldn't worry about time.
My Lord, for purposes of that issue, if I could just finish. The problem that we have, because we need to organize ourselves, that the time that has been given, one is going to do this and the other. Why that is absolutely important is that at this particular stage, because this has been a recurring thing, that there is instructions to be carried out. This is a court of record. We would want a fair allocation of time from the inception so that we are able to feel that at the end of the day, we did not refer to the court as a substandard case or an incomplete case. So it is only the minimum fairness that we should have.
But may I say something on the issue of time before the court gives directions?
Let time not be the issue here. Advocate Ongaya, please sit down. let time not be the issue here. Time can be availed. We can be here the whole of this day. We can be here the whole of this day. So let time not be the issue of discomfort. We will give you the time you want.
Thank you so much, my lord. That's an impressive direction.
My Lord, Your Ladyship, the sole purpose of conservatory orders under Article 23 of the Constitution, which gives this court power to issue conservatory orders, is to preserve the substratum, the subject matter of the petition. Here, what is being preserved is the right, constitutional rights of the deputy president who has challenged the impeachment for violating his rights, seeks to have that impeachment vacated and quashed. That is what needs to be preserved, and that is the purpose for which 3 judges issued conservatory orders, or 2 judges issued conservatory orders. But my lords, Your Ladyship, those 3 judges sitting separately, each one of them made a finding that there were serious, weighty constitutional issues raised that needed to be fully canvassed during the hearing of the petition, for the court to have the opportunity to give a considered decision on those issues, and therefore gave conservatory orders to preserve the subject matter so that the deputy president remains in office. There is no vacuum, there is no insecurity. My Lord, the best guarantor for security is observance of the rule of law, constitutionalism, and the Constitution. And this is the court that has that weighted duty of ensuring that that happens. My lords, the weighty issues identified by the 3 judges are: 1, the issue of public participation. The petitioner here says the public participation was a sham. We will be going into that through my colleagues. I'm just saying the weighty issues here. The second issue was the constitutional validity of Standing Order 68, giving a period of only 12 days to finish the whole purpose of the impeachment. And I would like to mention this issue of public participation, and indeed the time of 12 days, assumes added importance when we remember the wording of Article 1. The wording of Article 1 is that sovereignty remains in the people of Kenya. They have donated that power, that sovereignty, to your lordships, to your leadership, to the judiciary. They have donated their power to Parliament, the National Assembly, and the Senate, and they have donated that power to the executive. But the people of Kenya remain sovereign. That is why there must be adequate public participation in terms of the decision in the British tobacco case. The third issue was proof. The threshold, serious violations of the Constitution, which the Deputy President says do not exist in his place. Our opponents will be pointing out to you where it is that undermining the President is one of the grounds. My lords, the people of Kenya, in retaining sovereignty in themselves, elected leaders, members of parliament, senators, deputy president, the president, to serve them. They are the employers. The deputy president, the president, the members of parliament are employed by the people of Kenya. And therefore, the people of Kenya have got a right to see how the people they have employed are discharging the duties they have been given. We look up to you, my lords, your leadership, to be the bench, what the judiciary is what the people of Kenya look up to hold the country together in terms of observance of the Constitution and of the rule of law. The people of Kenya, in electing the deputy president and the president and the senators and everybody else who is elected, they were not electing to go back to imperial presidency. And it is for this court to ensure that we do not go back to the imperial presidency where the Constitution and the rule of law are replaced by the wishes of one individual. I hand over to my colleague, Elisha Ongoya.
My Lord, for the record and for the interest of those who are transcribing the proceedings, my name is Elisha Ongoya. I appear for the first petitioner applicant, His Excellency Rigathi Gachagua, Deputy President of the Republic of Kenya. My Lord, I stand here to canvass the Deputy President's application dated 18th October 2024, which in the main seeks that you halt implementation, or put appropriately, further implementation of the resolution of the Senate made on 17th October 2024. Allow me to then also put on record that we have some written submissions that were filed, and I think it's good practice to draw the court's attention to them so that the record confirms that they are part of the record. We had filed some written submissions on 22nd October 2024. We adopt and reiterate the contents of those submissions. When we retire, we urge you to have a look at them. But we also filed some additional written submissions on 28th October 2024. Both of them are entitled petitioners' submissions on the application dated 18th October 2024. Let me move into the substance of what I want this court to consider this morning. And I want to make some overall observations, my lords and my lady. I prefer to look at this case in this court as an opportunity for our constitutional order. Whereas I know that there may be Kenyans out there interested in this matter, looking at this moment as a challenge to our democracy and a challenge to our constitutional order, I bear a message of hope. I want us to look at these proceedings as an opportunity for our constitutional order. So the challenge for me, my lords and my lady, is how we shall seize and use this opportunity. I look at it as an opportunity for our governance institutions. My lords will remember the words of the late Justice Chunlal Magwanda's Madan in that famous case of Githunguri versus Republic, where he urged Githunguri to run unto the hills, face east, and thank his gods that Kenya is a country under the Constitution. I see this as another opportunity. I beseech this court to urge His Excellency Rigathi Gachagua to run to the top of Mount Kenya, face east, and tell the world that Kenya is a country under the Constitution through the opportunity presented by this case. I see this case as an opportunity for the judiciary, and I'll be elaborating on this point in a short while because of the behavior of other organs of government in the recent past. So I see this as an opportunity for the judiciary. I see this case as an opportunity for righting wrongs and not for perpetuating wrongs. I have had the privilege of participating in these proceedings from the National Assembly, through the Senate, through this court. And I thank God and thank my client for that, because out of 50 million Kenyans, I have done nothing special to deserve this opportunity, but this somehow fate has conspired to give me an opportunity to participate and witness these events from the front benches. What this case has taught me is just how perilous we stand as a country if we depend on our legislative and executive institutions, and very recently, our constitutional commissions. Our remaining beacon of hope, my lords and my lady, is this judiciary. I have one question for you, my lords, my ladies. Will you drop the ball, or will you hold the ball to the finish line? A brief history of what you will find in our amended petition, by way of paraphrasing, is that on 18th October 2024, this country witnessed an unprecedented hurry by our executive, legislative organs, and our constitutional commissions to beat our constitutional order. I'll demonstrate this shortly. On that day, 18th October 2024, we witnessed an unprecedented hurry. In fact, I would have thought, speaking for myself, that our country has become super efficient. But I discovered that no, we were still waiting long to get our national IDs. We were still waiting long to get our passports. We were still queuing for long in our hospitals for health services. That this unprecedented hurry was for a specified project to beat our constitutional order. And why do I demonstrate this? A process for which the Constitution of Kenya prescribes 74 days at Article 149, Clause 1 of the Constitution was truncated and executed in less than 6 hours. Clearly, we may have varying definitions of the word hurry, but we can build consensus that this one is undisputedly unprecedented hurry. Why did the makers of our Constitution prescribe 74 days maximum in Article 149, Clause 1? Different analysts may give it different interpretations. I beseech you to find whatever the scope of interpretations, the following will fit into them. Number one, it must have been to give the process optimum transparency. Number two, it must have been to give the process optimum accountability. Number three, it must have been to give the process procedural fairness. Because whereas we know that justice delayed is justice denied, we also know that justice hurried is justice miscarried. And finally, it must also have been to give public participation in the process under Article 149, Clause 1, some chance. Allow me to submit at that juncture from the very outset that the process undertaken by the President of the Republic of Kenya, by the Ethics and Anti-Corruption Commission, which was mentioned in the President's communique to Parliament, to the National Assembly, by the IEBC, that was also included in the President's communique to the National Assembly, and by the National Assembly itself, did not even pretend to have an iota of public participation. Even the pretense of public participation was now taken away. We will demonstrate to you that the process between 1st October and 17th October, the process between 1st October, when a notice of motion was given in the National Assembly, to 17th October, when a resolution was taken by the Senate, had pretenses, half-hearted pretenses of public participation. That will demonstrate. The process on 18th October, buoyed by any lack of checks, buoyed by the fact that any attempt at checking the institutions had not yielded fruit, now they became brazen. They now undertook a process on 18th October, now completely without any pretense of public participation. There is no single Kenyan who was given a chance to ever say what their take is on Honorable Kithure Kindiki, my law lecturer of yesteryears and a fundamental scholar, my good people. No Kenyan was given a chance to give any thought on whether or not he is suitable to be deputy president. No member of the public, no memoranda was received, no meeting was called anywhere for anyone to give any thoughts. No email address was given to be crushed by Kenyans, as we now know Kenyans can do it. Completely, no pretense at public participation. I'm emphasizing these points, my lords and my lady, to demonstrate the point I made earlier, that we have now been taught how perilous it is for us to rely on our executive institutions and our legislative institutions and our constitutional commissions as defenders of our Constitution. We are now left with only one institution, this judiciary. I don't know where that noise is from within here. Thank you. If they are doing renovations, they may be told that this is so important a day for renovations. We may defer them to another day. And let's face it. Let's face it. The process of 18th October 2024 took 6 hours as a deliberate scheme to defeat each of the principles and values of good governance I have alluded to: transparency, accountability, procedural fairness, and public participation. Who did these violations? We are also here to call people to account. Who did it? Between the time we left Senate around midnight, between the time Senate closed business around midnight of 17th October 2024, and the time we woke up to the presidential communique of 18th October 2024, in that night, the Bishop Oginde-led Ethics and Anti-Corruption Commission is documented in the President's memorandum to have received, processed, and given a clearance to Honorable Kithure Kindiki. That night. My lords, history is important, and I may not remind you why our Constitution prescribes that our presidents be sworn in during the day. We were all adults, we know where that comes from. It's one of the most autochthonous provisions of our Constitution. And therefore, when things happen in the night, we have reason to have our antennas high. Between the time Senate rose on the night of 17th October 2024 and the time we woke up in the morning of 18th October 2024 to the President's communication to the National Assembly, we were told that the IEBC, which we now know is not properly constituted, has no commissioners, had purportedly cleared Honorable Kithure Kindiki in the night. I will not say much about KRA because I think KRA can work overnight and we will not complain. But it was that memorandum. The other culprit was the President himself. The President of the Republic of Kenya undertook these clearances overnight and in the morning had a clear, proofread memorandum. Exceptional efficiency, we celebrate that. To Parliament. Then the National Assembly itself. Now this is curious. The National Assembly itself had called a sitting prior to the resolution of the Senate. The sitting was called prior to the resolution of the Senate. To sit on a day, ordinarily not a day of sitting of the National Assembly, to process a resolution of Senate it had anticipated, the removal of a deputy president from office, and processing clearance or approval of another deputy president. We sit here as judges, we sit here as court assistants, we sit here as advocates representing various parties. I don't know who among us, once we take away the cloaks of the official roles we play, was proud as a Kenyan observing these events as they happened. I don't know who among us was proud now putting on the cloak of citizenship to watch these events unfold at that pace. Fortunately for us, my lords, my ladies, we have a judiciary of Honorable Richard Mwongo that arrested this process in its tracks to give the Constitution a chance to roar in the far corners of Kerogoya. Fortunately for us, we have the judiciary of Honorable Chacha Muita, His Lordship, that arrested this process to give the Constitution a chance. Today, you sit and I stand before the judiciary of Honorable Ike Ogola, Honorable Esim Rima, and Honorable Dr. Frida Mugambi, that has been invited by the respondents to undo that chance that the Honorable Muita and the Honorable Mwongo gave the Constitution. We don't begrudge them for that invitation. Because under Article 48, they are entitled to come here and make that invitation. Our question is whether the judiciary of Honorable Gola, Honorable Mrima, and Honorable Dr. Frida Mugambi will be baited by that invitation. That's our only question. Throughout these proceedings, we shall be looking at you in the eye to ask, will you fall for this bait or will you stand for the Constitution? Having laid out our broad attitudinal view of this matter, allow me to address you now on the law and the jurisprudence of conservatory orders. In terms of textual prescription, in terms of the prescription of text of the Constitution, we will find accommodation for conservatory orders in two aspects of Article 23, Clause 3 of the Constitution. Article 23, Clause 3 says, in any proceedings brought under Article 22, a court may grant appropriate relief. So we find accommodation of conservatory orders in the use of the phrase appropriate relief. Because appropriate relief is wide enough to accommodate anything under the sun that is necessary to give effect to a right, fundamental freedom, or I dare say, any other provision of the Constitution. The second accommodation is in paragraph C of clause 3 of Article 23, which says, in any proceedings brought under Article 22, a court may grant appropriate relief, including, say, a conservatory order, expressly. I'm a bearer of good news that in determining whether or not to grant conservatory, to confirm these conservatory orders, my lords, you need not look further than in the files before you. I'll demonstrate you shortly. Just by looking at the files before you, you will see why you must confirm these conservatory orders. Let me go there. Allow me to address the brief issue of your jurisdiction over this matter from the files before you. I would invite you, when you retire, to look at the ruling of your brother, Justice Muita, of 15th October 2024 in petition number 550 of 2024. When you look at that ruling, I would invite you to look at page number 7 of that ruling, there is a paragraph 7. The way that ruling was processed was that each theme the judge addressed it by beginning with paragraph 1 to the last, then another theme, paragraph 1. So you'll see a lot of paragraphs 1, 2, 3, then it ends, and we begin paragraph 1 again. So you look at the paragraph 7 at page 7 of that ruling of Chacha Mwita in petition number 550 of 2024. For the benefit of this court, for the benefit of everybody who is listening, Honorable Chacha Mwita said the following things at paragraph 7, that the petitioner also argues that constitutional imperatives in conducting public participation were not met. The claim falls within the scheme of Article 165(3), so that this court has jurisdiction to interrogate whether any of constitutional processes said to have been conducted under its authority met the constitutional threshold. The judge has already established that the argument on public participation raised by the petitioners falls within the jurisdiction of this court under Article 165, Clause 3. Then, paragraph 9 of that ruling on the same page. Justice Chacha Mwita holds, first he observes that the first respondent has pushed an argument that this court has no jurisdiction to hear a matter arising from impeachment of the president or deputy president on the basis of Article 165(3)(c). Then he reproduces the provisions of the article verbatim. I wouldn't want to regurgitate that because you'll read it. He proceeds now to argue that Article 165(3)(c) is in relation to the process of removing the president or a deputy president from office on grounds of incapacity. This process is initiated for purposes of investigating the president or deputy president's physical or mental capacity to perform functions of that office. And here's the clincher. This is a distinct process from that of impeachment in Article 145 as read with Article 150. Article 163(c) excludes jurisdiction of this court over the process undertaken in accordance with Article 144 and not Article 145 as read with Article 150 of the Constitution. Honorable Chacha Mwita has made a finding that this court has jurisdiction over a matter or a process undertaken under Article 145 as read with Article 150 of the Constitution. If you turn to page 9 of that same ruling, of Justice Chacha Mwita of 15th October 2024 in petition number 550, page 9, you will find another paragraph 4. I think I explained why these paragraphs run back and forth. Paragraph 4, he says, I'll read paragraph 4 and 5, so for full effect. Paragraph 4, Article 145 lays down the procedure to be followed in cases of impeachment and the timelines for doing so, including affording the person an opportunity to be heard on the charges. I have considered the constitutional provisions on impeachment and read decisions from the Supreme Court and the Court of Appeal, which are binding on this court. These decisions have laid down the position that it is important to let the impeachment process run its course, after which the court would have a look at any complaints on violation of either the Constitution, the law, or fundamental rights, including processes. After which the court would have a look at any complaints. He's again asserting the jurisdiction of this court at this stage. Then, I would also invite you to look at at page 10 of that same ruling. At that same ruling. And this is the clearest warning that Justice Chacha Mwita was sending to the National Executive and the National Legislative Institutions Parliament. At paragraph 9 on page 10, he observes, in other words, constitutional processes are not about dashing to the finishing line, which is what they were doing. It's not about that. They were being told what you are doing is child's play. And we are not here about child's play, we are here about the Constitution. He says they have constitutional imperatives that must be complied with. And if not, such infractions will not be out of reach of our Constitution. He completes by saying, where there is an allegation that fundamental imperatives in the Constitution have not been complied with, which is the allegation that you have before you, my lords, my lady, the affected person, my client, His Excellency Rigathi Gachagua, has recourse to court, and the court will have to determine whether the state organ complied with the Constitution or the law. Has recourse to court. I began by saying we need not look further than in the files before you to assert that these orders have been confirmed, and I'm beginning by confronting the unfortunate allegation of lack of jurisdiction that has been filed on behalf of the person who was nominated to be the deputy president and who is supposed to uphold the Constitution. At paragraph 10, he gives the most enduring philosophical statement of page 10, paragraph 10, page 10. In that respect, our Constitution offers both hope and promise. Hope that the institutions it has established will comply with its fundamental principles. We now know that that was hope against hope. And promise that the Constitution is supreme, and any act or omission in contravention of the Constitution is invalid. In other words, it does not matter how far the process may have gone, since no action is beyond the reach of our Constitution. My lords, I want to speak the truth here. In the face of these pre-existing rulings in these files, you will hear arguments here of non-justiciability of this dispute, political question doctrines, things that have been fished in a cut and paste manner from old American jurisprudence into a transformative constitution of the 21st century. I mean, that's unfortunate. I am hoping that once I'm done with this, those who came to court carrying those arguments of political question doctrine, non-justiciability, will find favor in abandoning them to save us some time. At the same page 10, you'll find another paragraph 1. I tell you the judge was starting paragraph 1 at every new issue. He says, Article 2, Clause 4 of our Constitution is not only the hope, but also the promise of our Constitution that we must abide by constitutional dictates, for any act or omission in contravention of this Constitution is invalid. That's what the judge is telling us. When you look at the files before you, my lords, you'll also find the ruling of your brother, Justice L.N. Mugambi, in petition number 522 of 2024, His Excellency Rigathi Gachagua versus the Speaker of the National Assembly and others. Another file that is before you. At page 9 of that ruling, you will find paragraph number 34. In that paragraph, the judge observes, and that was when he was delivering the ruling to send this file to the Chief Justice to empanel the three of you to sit. He says, Article 165, Clause 3, Paragraph B or D of the Constitution has been delineated by Article 165, Clause 4 as constituting areas from which substantial questions of law might arise to require composition of a bench. He then goes ahead and reproduces Article 165, Clause 3, B and D. He's saying, before he sends this file to the Chief Justice to empanel a bench, he must satisfy himself that the dispute in question falls within Article 165, Clause 3, Paragraph B or D. And he made the determination that the dispute falls within Paragraph 165, Clause 3, Article 165, Clause 3, Paragraph B and D, and send the file to the Chief Justice to empanel the three of you. The three of you are sitting on this bench on a finding that the court has jurisdiction. In the absence of that, the dispute would have been outside the ambit of Article 165(4) for empaneling of a bench. Then there is your own jurisprudence as this bench. "13 days ago, on 16th of October, 2024. 13 days ago, the three of you, my Lord Justice Ogola, my Lord Justice Mrima, my Lady Justice Frida Mugambi, delivered yourselves on this question of jurisdiction. In that ruling, in petition number 522, as consolidated now with the others, in that ruling that you delivered on 16th of October, at paragraph 83, you observed that at the moment, that was at that time, this court is being called upon to anticipate the outcome of a process yet to be completed. The application at this point is premature and anticipatory. In any event, should the petitioners not succeed before the Senate, they still have an opportunity to approach the courts. The applicants cannot therefore say they have no remedy. Now, I was asking myself as I prepared, I'm imagining you now telling us, no, you have no jurisdiction. Having told us this, my Lord, how will you look at each other? How will you look at us? You told us yourselves, go to Senate. Once you have finished, come here. Then we come here and you agree with my friend Dr. Mudomi Thiankolu, these are political questions and therefore we cannot deal with them. These matters are unjusticiable. How basic decency militates against at least the three of you, saying you have no jurisdiction. I respectfully submit, my lords, my lady. You observed at paragraph 85 that this court, and I was asking myself, what does the word this court mean? This court means two things. You said, this court has unfettered jurisdiction to check the constitutionality of the process at whatever stage. As such, we are certain that the petitioner's rights are currently well guarded and none of the petitioners stands to suffer any prejudice. You assured us that you have unfettered jurisdiction, that's what we used, jurisdiction, to check the process at whatever stage. I've said the word this court, I understood it to mean two things. One, to mean the High Court, because you are talking about this court. I don't think you had forgotten you are judges of the High Court. So that when somebody comes and says, we ought to have gone to the Supreme Court, they must also justify to you why you are using the words this court in this context. And number two, it means this bench. The three of you sitting here as a bench. You are now this court in this matter. You have unfettered jurisdiction to check the constitutionality of the process at whatever stage. At paragraph 87, you reiterated that you are exercising judicial restraint in order to accord constitutional entities the latitude to deal with their mandates. But then you said, we however clarify that courts can and ought to readily intervene in ongoing processes before any entity in the clearest of cases where there is evidence of flagrant and gross violation of human rights and fundamental freedoms. I began by telling you, the most flagrant is the happening of 18th of October, 2024. The most undebatable. The National Assembly received a nomination of Honorable Kithure Kindiki from the President. The National Assembly had in its face Article 118 of the Constitution. In its face. I'm sure some members are sitting here of the National Assembly. They had in their face Article 118 of the Constitution. That article continued to pronounce itself because Article 259 says the law is always speaking. So this article was consistently speaking to the National Assembly. Consistently speaking that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The law continuously spoke. The Speaker called the House Business Committee. They met. Article 118 was speaking to that committee that you shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. That committee turned a blind ear to this speech by the Constitution. They sat in plenary. Article 118 1B was speaking that you will facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The plenary turned a deaf ear. 2, this dictate. The most blatant. I want to ask how we cannot stop the confirmation, the assumption of office of Honorable Kindiki on this argument only until we argue this matter fully and settle it at the hearing of the main petition. I want to see. I'm a career learner. If you convince me, I can tell my clients they have convinced me. But I'm trying to imagine the kind of philosophy you will require to convince me. The 50 million Kenyans out there know. None of them was ever called upon to make any view, any thought on the suitability or otherwise of Honorable Kithure Kindiki to be the Deputy President of Kenya. They know. Then, at paragraph 90 of that ruling, you observed, in other words, this court is still able to grant a remedy even after the process in Parliament is concluded. You again asserted your jurisdiction. I want to conclude this aspect of my submissions, my lords, my ladies, by pointing out that it's a high time that we laughed out of this court anyone who questions the jurisdiction of this court in this matter in view of all these prior rulings in the files before you. Allow me to then briefly address you on the other aspects of issuance of conservatory orders. Again, I will not go further than your own earlier rulings. In your ruling of 16th October 2024, at paragraphs 62 to 71, you pronounced yourselves on the principles that govern grant of conservatory orders. We agree with each of those principles that you set out in that ruling without any modification. we agree with each of the principles that you set out in paragraphs 61, sorry, my apologies, 62 all the way to 71. I will address myself to only one aspect of those principles and invite my learned colleague, Mr. Macharia, to address the remaining aspects. This is where you allude to the case of Gatirau Peter Munya versus Dixon Mwenda Githinji and two others. If I'm not mistaken, this must have been the matter that was argued by my colleague, Dr. Tiankolu, some times back, so he would know it very well. It was among the first cases to deal with this matter. It's actually the first one in the Supreme Court of Kenya. And you see, we celebrate Dr. Mudhomi Tiankolu for contributing to this kind of jurisprudence. He observes, and I quote, that conservatory orders, consequently, should be granted on the inherent merits of a case, bearing in mind the public interest, caution of values, and the proportionate magnitudes and priority levels attributable to the relevant causes. I want to address myself to the inherent merit of this case and just on one aspect of public interest. In fact, let me just begin by putting aside the issue of public interest, by asserting as a principle, my lords, that I desire that you hold that the greatest public interest is upholding our Constitution. There can be no superior public interest attributable to politics or other considerations that would outweigh upholding our Constitution. In fact, that is my understanding of Articles 2 and Article 3 of the Constitution. Articles 2 and 3 of our Constitution provide that the greatest public interest is in upholding our Constitution. I can see my learned colleagues jittery. I don't know whether they want to raise an objection. Okay, thank you.
Not me. I would never raise an objection regarding you.
Thank you so much, my teacher and mentor, Professor Gedum Muigai. And I'm sure our other colleagues have taken cue from you, Prof. So that, my lords, when a petitioner raises a matter like the clearest violation I have raised on what transpired on 18th, there can be no greater public interest than giving that matter a chance to be ventilated fully. I can't imagine of any. But having said that, let me now deal with how this petition meets the inherent merits test.
Just a minute. We had earlier on given a time allocation, which Mr. Kibe disagreed with and asked for 2 hours. We will give you that 2 hours and not beyond. You have done 1 hour.
Okay, let me now take 15 minutes to summarize the rest of the argument. Then we see how to wind up that. So let me address the issue of inherent merit, because that's my last argument. Then I can see what my learned colleague, Mr. Macharia, can mop up. We had gotten another indication, my lord, that we have the whole day. That's the last direction you gave before this one. So that's why your words, my lord. I'm sure the transcript will come out with those words.
That is, we speak as Africans.
Let me do the best I can in view of the new direction, because that has made me now to change my approach, which can...
Certainly, Mr. Ongoya, you didn't expect that we have the whole day. We had given directions on time,
yes,
and on your own authority of Mr. Kibe, he said you would want 2 hours. And we have agreed to that. So let's stick to the petitioner's side having 2 hours.
Let me give it my best. We'll deal with the eventualities. Allow me then just to refer you to a few things. On your ruling of 16th October 2024, at paragraph 78, you observed And I quote, "In sum, therefore, in determining whether a matter discloses a prima facie case, a court must look at the case as a whole. It must weigh, albeit preliminarily, the pleadings, the factual basis, the respective parties' positions, the remedies sought, and the law.